All right, welcome everyone once again to our webinar over the 4E policy changes. I will quickly orient everyone to the room before we jump into the content today. Just a quick note here. This webinar was developed through funding from the Division of Social Services by the Family and Children's Resource Program here at the UNC School of Social Work. Another quick note, let me put up this file share box here. In case you had overlooked an email with the slide handouts, here they are. There is a file share box you should see here where you can click on the download icon and you can save these slide handouts and of course have them open and available so you can review them now or later. So I'll give you a moment. Go ahead and click on the slide handouts if you don't already have those available. And I can bring them back up later in the presentation too. Okay. So here are our goals for this webinar today. Our presenters will explain the definition of candidacy for foster care with an emphasis on how to apply it to claiming for CPS In-Home Services. Also, our presenters will explain when 4E funds can properly be claimed for reimbursement of administrative costs, work or time, for children in foster care, and more specifically we'll dig into how the Family First Prevention Services Act 14-day 4E maintenance claiming limit does not affect administrative claiming. General rules for when administrative costs can be claimed for case management services to foster children and the exceptions to those general rules, and how to correctly use field 55 on the DSS 5094. And I'm seeing a question about handouts. They were emailed to you if you registered for this event, and here they are here. If you want to click on the file share box, you'll see a download icon there. You can save those slide handouts and have them open and available for yourself. I'll leave them up here while I just discuss the chat box. So the chat pod here, most of you are already finding this. Thank you for the many good mornings. That is one way you can reach out to us today. We don't have mic capability because there are over 100 folks registered for today's event. So this will be your primary way that you can communicate with us. So if you have a question, for example, you can type it in the chat to everyone. Everyone will see it. Or if you have something more of a private nature, you will see at the top left of that chat box, there's a little plus sign. You can open up and just send a chat to the host. That would be those of us here at UNC or the presenters. Or of course, just an individual you can send a chat to specifically. So this chat box in general is going to move pretty fast. We do have someone here providing technical support to capture your questions as you are chatting about them. All right, and about these questions. So we'll be monitoring your questions as you type them in. At times our presenters may be able to quickly answer something if they see a question come up that they're covering that content, but otherwise we're also setting aside hopefully just a couple minutes at the end of their presentation to address remaining questions. And if nothing else, we have run out of time the last 2 days. That's okay, because we actually have a follow-up document we're preparing that will capture all the questions being asked from these 3 events. We had one Tuesday, we had one Wednesday, and this is our final one today. So all those questions being asked by you, we're capturing them, and there'll be a FAQ document that will send out to all registered participants. It's also going to be posted with the recorded webinar. Those links you see there through NCSW Learn, and that's the direct link to our website through Family and Children's Resource Program, where you'll see a whole lot of other webinars available if you wanted to look through those. But we will post the follow-up document along with the webinar soon enough. Here's another way you can get our attention. Aside from the chat box, you can use the icons on the top toolbar there. You'll see a little hand raised icon. If you drop down next to that, you can tell us, for example, to speak louder, slow down, or of course give our presenter some applause. Again, there are over 100 people registered today. We don't have mics, so use the chat box or use that icon there to communicate with us today. I'm going to open up a poll really quick. This will help our presenters know a little bit more about our audience today. So you should see a polling question there on your screen. What's your level of understanding when it comes to determining candidacy for foster care? You can answer that 1, 2, 3, 4, 5, where 5 means I'm an expert. I'll give you a moment. Please respond to that. And you should be able to see here, it looks like the majority of our group today is at about a 3, which has actually been the majority for the past 2 days too. So thank you for giving us a little bit of data that helps our presenters. I'm going to hide that. And here are our presenters today. Again, I'd like to welcome each of you to attending this webinar. I'm Rick Zeckman. I work with the Family and Children's Resource Program at the UNC School of Social Work. I'll be your host today. We do have technical help from our colleagues Philip Armfield. So if you're having any technical difficulties, please chat about them and Philip will try and help you out. Also, John McMahon is capturing your many questions that you're answering or that you're asking so that we make sure that we can get them answered in our follow-up document. And our presenters, we have Beth Riley from the Division of Social Services and Evan Friedel from UNC today. Beth, can you jump on the mic and introduce yourself and tell us what you do?
Thank you, Rick. I am Beth Riley. I am the Title IV coordinator with the North Carolina Division of Social Services. Prior to my role as the Title IV coordinator, I was the Adoption Services Program Manager. I also served as the Adoption Assistance Consultant with the division, working with Evan when he was in this capacity as a Title IV coordinator. And I served a little bit in the adoption services with the team with Adoption Index and Review. So I've been with the division for about 5 years. So that's a little bit about me. Thank you.
Thank you, Beth. And Evan, can you introduce yourself?
Good morning, everybody, and welcome. We are thrilled to have you all here with us this morning. My name's Evan Friedel. I am a training specialist with the UNC School of Social Work Family Children's Resource Program. I've been with FCRP since August of 2021. Prior to that, I spent about 14 years with the Division of Social Services. Most recently, I was the Title IV coordinator, held that role for about 3 years. Before that, I worked as a CPR, the role that is now known as a regional child welfare consultant. Also in that time, I was voluntold. Many of you are familiar with voluntold. Over to NC FAST and worked with the NC FAST team helping to develop the child welfare module. I'm very fond of saying, and some of you have heard me say it more than once, that anything that you like in NC FAST, I definitely was involved in the development of that part. Anything you don't like, I wasn't a part of those work groups. So that's just something for y'all to know. Prior to my time with the division, I worked in Forsyth County. I was a program manager over all areas of child welfare. I also worked as a supervisor in foster care. Prior to that, I've worked with the North Carolina Eye Bank, working with and for eye and cornea donation for research and transplant. I've also worked with Hospice of Winston-Salem and also worked with North Carolina Baptist Hospital in their cardiology program as a social worker and also their heart transplant program. So I have had a very varied career and/or I have one of the strongest cases of job ADD you can ever count. But I am thrilled to be here today to present this topic with you and look forward to our next 90 minutes together.
Thank you both, Evan and Beth, for assisting us with this learning opportunity today. I will provide their contact information at the end, so you'll have that if you wanted to reach out to them directly. I'm already seeing some questions in our chat about maybe training credit for this. If you're not registered, I'll post that information about, again, where you will find this recorded webinar probably sometime next week. So that if you have a colleague that didn't register, they can go back and review this, and certainly you can add training credit manually through NCSW Learn. I can post that in the chat box. But in the meantime, at this point, I am going to turn it over to Evan to give us a little background about what 4E is.
Great, and thank you, Rick, for that introduction. And I do want to encourage everybody, please use the chat pod. You all have been jumping in with that, but that is going to be the absolute best way to make sure we get all of your questions addressed today, whether Beth and I are able to answer them for you right during this morning or answer them as part of the FAQ follow-up document. We definitely want your questions. I guarantee you there are going to be no silly questions today. If you're wondering about something that we're talking about, someone else on this webinar is wondering about it as well. So there are no silly questions. There may be silly presenters who tell horrible dad jokes, but there are no silly questions. So please don't hesitate to throw stuff up there. As Rick mentioned in the intro, some of our goals are to talk about some of the new pieces of 4E legislation or policy that affect our day-to-day. But before we can look forward, we have to make sure we can look back and understand where we've been and what our history is. So I want to tell you a little bit about the background of 4E and what 4E is and equally what it isn't. A lot of people, when they think about 4E, they think about it purely as a funding source. And while it does provide funding and reimbursement for services that counties provide on behalf of children or pay for children, like room and board or worker time, it's also a series of protections that are required to be provided both to children and to parents, parents' legal rights protections, as well as physical protections for children. And 4E was officially created. It came into being in 1980 as part of the Social Security Act. The federal government has shared in the cost of foster care since 1961, but 4E was added to the Social Security Act in 1980. The intent was then and remains to provide, when appropriate, i.e. when the child is eligible and is in an appropriate placement, foster care assistance for children who otherwise would have been eligible for federal benefits through the AFDC program. The AFDC program does not exist currently, but we still use it as our benchmark for qualifications for children who are entering foster care or may be candidates for foster care. What's important also to know about 4E from the funding side of things, it's an uncapped reimbursement. And what that means is basically as long as you bill 4E for appropriate costs, meaning the child is eligible and in an appropriate placement, you will get reimbursed based on the percentages that are allowed on an unlimited basis. Unlike other funds that are capped, the capped fund is a lot like your checking account. The easiest way to think about it is you have a set amount of money in that checking account on any given day. If you write more checks than the amount that's in there, they won't get paid. So a capped fund, when you run out of money, there's no more. You can bill to it all day long, but no more money is going to flow. In an uncapped fund like 4E, you can keep writing those checks, and as long as it's an appropriate expense, they will continue to be paid. But because nothing ever comes for free, the federal government requires states and tribal organizations to develop a plan based on the federal requirements of 4E to tell the federal government how they plan on meeting those requirements, how they plan on providing those protections, and update that plan as requirements and regulations change. And those changes primarily come through legislative acts. Some of the additions and changes to 4E that have come since its introduction in 1980 are through some child welfare actions that you're very familiar with, MEPA, AFSFA, and more recently the Fostering Connections Act, the Increasing Adoptions Act, and the newest legislative change that affects 4E, FPSA, the Family First Preservation Services Act. This was passed in 2018, February of 2018. And while it covered a number of issues across the spectrum of child welfare, there was one major change focused on 4E reimbursement for children in group homes. And many of you are familiar with this already, especially if you're working in foster care. There have been numerous communications from the division about this through DCDLs. But the major change was that for children who were put into new group home placements as of October 1st, 2021, 4E, if they were 4E eligible, they would only be able to get 4E reimbursement for maintenance cost. And remember, maintenance is room and board. We'll discuss this, the difference between those two, several times today. But on the maintenance cost, you're only allowed to get reimbursed from the federal government for 4E for a maximum of 2 weeks. And that is a significant change to a number of our children across the board. North Carolina took the opportunity that the changes that FPSA was providing to review not only the 4E plan as a whole, but also related policies, fiscal policy, practice policy in foster care, as well as areas of eligibility as it relates to candidacy in in-home services. So we're going to be talking about today how some of these policy and practice changes affect the practice you all have going forward. And the first area that we're going to discuss is candidacy. So when I say candidacy, you may be wondering exactly what I mean. And I would tell you that is a great question. Evan, what do you mean by candidacy? Well, let's find out. What I mean by candidacy is going to be the Title 4E definition of a candidate for foster care. And that's defined as a child at imminent or serious risk of removal from the home into foster care, as evidenced by the county child welfare agencies making efforts either to prevent removal or in the process of pursuing removal. And that quote comes right out of the policy manual. You see the link at the bottom there that links you to the policy manual. It's in the cross-function policy. Because candidacy can apply in multiple areas of our practice, the division felt cross-function was an excellent place for that to live. So that will take you there if you need a reference point for that. I do recommend that you constantly bookmark these websites and don't just print the manual and keep it as a given copy, because policy will be updated from time to time. And when policy is updated, the link to policy will always ensure you have the most updated policy. Whereas if you're using just a printed copy of the manual or forms, you may not always be using the most updated version. So when we talk about candidacy, and thank you, John. John just put in the chat pod the link to the policy manual as a whole, so that'll take you to the basic policy manual, and you can select different areas if you need to. Throughout today's presentation on different slides, we may have specific links that'll take you to specific areas of the policy. So you get the general if you want the trees, or the forest rather, or you get the trees, as it may be. Depends on what your need is at that particular time. But when it talks about in this definition as evidenced by, basically that means we need to be looking at how we're going to document it. How are we going to provide that evidence? Because as you all know, especially in child welfare, if something didn't get documented, it essentially didn't happen. Many of you who've been in trainings with me before have heard me say, you know, we want to make sure you're getting credit for the good work you do. And you're doing excellent work in general with the children and families you're working with. The issues come up in audits and reviews when it hasn't been documented correctly. So when we talk about documenting candidacy and providing evidence, we need to make sure we understand what acceptable documentation is. And acceptable documentation and evidence for candidacy is seen in North Carolina as a written case plan developed with the family, and I'm going to circle back to that in a minute, that clearly indicates, absent preventative services, that foster care is going to be the planned arrangement for the child, and that it describes the services used to prevent removal. This is really a three-part process. The first one is understanding that we are developing a written case plan with the family, not for the family and not to the family, and to be honest, not by the family. We don't want the family to write up a case plan and say, this is what we want to do. We equally don't want to go ahead and write up a case plan and take it to the family and say, here's your case plan, please sign it. We want to be able to develop it with the family. And the document that we use in North Carolina for this is the In-Home Family Services Agreement, the DSS 5239. Okay? It's important to understand that while many of the questions on the DSS 5010A address similar items that the 5239 uses, a 5010A is not seen as acceptable documentation by the division for supporting the documentation of candidacy. You will support your documentation of candidacy and provide evidence when you have a completed and signed 5239. Now further, even though the document in the 5239 allows, if you have multiple siblings in a family, you can start with that documentation by listing the multiple siblings on that, and in many places in that document you're able to have the whole family in one document. Page 10 of the 5239, which is utilized for the evidence of candidacy, you must have a separate page 10 for every child in the household, because eligibility must be determined individually for each child. It is possible and likely in certain cases, especially in foster care, we see this a lot, but even in in-home services, where different children in the same family have different eligibility based on their specific circumstances. So you have to go ahead and be able to ensure that a separate copy of page 10 is completed for each child. Now that can then be just added into the document. It can be scanned and uploaded. It can be stapled to the back. However your county works with the documentation process, you can do that, but it must be separate. Now, when you're working with page 10, the first box on page 10 instructs the worker to provide clear and concise language regarding the specific reasons the child is at imminent risk of removal if services are not promptly provided to prevent the county child welfare agency from taking custody. In that box, you're going to write the name of the child, the reason the child named is at imminent risk, and the preventative services to be offered to address that risk. Now, the services listed can be one or more of the services or activities that are described earlier in the plan. It's not like you're creating a new set of issues, a new set of reasons. However, you need to make sure that you are able to develop that plan and make sure you're connecting the dots between the fact that you're stating the child is imminent risk, you're saying why they're an imminent risk, and then you're connecting that to what you're doing to keep them from entering into foster care. And that can and should be most likely a combination of activities, what the family is expected to do and what you're able to do as a worker. Now, I do want to bring up again, I've seen this question come up a few times and it came up in other webinars. The 5010A does not meet the requirements for candidacy until the development of a 5239. So the 5010A alone does not meet that requirement by itself. And so we need to make sure that you go ahead and get the 5239 developed as soon as possible. Now we're going to talk about the fact that that doesn't necessarily mean you're going to lose eligibility depending on when you get the 5239 developed. So we're going to talk about that in a few minutes because that question has definitely come up. And it sort of dovetails into this next section, which has some of the questions we know people have asked as we address length of candidacy. So when can claiming begin? Claiming can begin on the first day of the month that the requirements are met. For example, if the child entered in-home services on January 3rd, but you don't get the case plan, the 5239, signed and completed until today, which is the 27th of January, you can go back and claim 4E for the entire month of January. So the fact that you got it done on January 27th still allows you to claim all of the month of January. Now, same child, they entered on January 3rd. However, you did not get the 5239 signed and completed until February 3rd. You would be able to go back until February 1st and claim 4E for that child for admin costs. And remember here, we're talking about admin costs. We're talking about day sheet codes. You can claim that for all of February, but all of January must be an alternative day sheet code, an alternative program code. You could not code Z for January in that second part of that example. Now, another question that's asked is how often must candidacy be documented? A written justification, according to the federal government, is required to retain a child in candidacy for longer than 6 months. What that means is every 6 months, at a minimum, you must recertify the child's eligibility. Now, you're more than likely, if you're following North Carolina policy, you're updating your case plan at least every 6 months, more frequently than that most likely. As long as you are updating page 10 and adding the issues that would keep a child in candidacy, then the child can remain considered a candidate and you can continue to claim. However, from a practice perspective, one of the things the division has long said is that it is critical to evaluate when you have children in-home services for an extended period of time without court action. It doesn't mean there aren't going to be cases that it's appropriate, but it means that from a supervisory and a worker standpoint, you should be staffing those cases and making sure that you look at it and say, why is this child still here? Why are we either not closing this case? Why are we not moving to custody? What's our goal and what's our expectation? And then ultimately, how do those goals and expectations roll into our determination or certification of candidacy? So it's a series of questions you have to ask, but the minimum requirement is that you would go ahead and update your justification/certification a minimum of once every 6 months. And then when must claiming stop? Well, it seems obvious, but it's important to remember that claiming has to stop when the child is no longer considered a candidate or when the requirements for candidacy are no longer met. So if the child no longer meets the candidacy requirements, then you need to stop. If the issues and reasons you've put into page 10 no longer apply, then that child would no longer be a candidate. However, if you have also, the circumstances still exist, but you have forgotten to update your certification after 6 months, as I mentioned just a minute ago, then your eligibility would stop after that 6 months period, and you could be liable for a payback for those claiming beyond the 6 month period. Now, some other things to consider and keep in mind as we're addressing candidacy. First of all, risk of maltreatment is not enough. Okay, you may do your risk assessment and determine a child and parent situation to be of high risk. That is a consideration, and it certainly may be pointing you in the direction of then connecting the rest of the dots as to why the child is a candidate. But them being high risk alone is not enough, because remember, there are certain things in the risk assessment that may make a child high risk that are beyond the control of the family. A family may have multiple reports from 8 years ago and have cleaned up their act and gotten themselves completely back on the right path, but those previous reports are going to stay with them, and a certain number of reports are going to add certain points to their score, and that may not be directly related to why this child is a candidate. So risk assessment alone is not enough, but it certainly can be a clue that there may be reasons this child should be a candidate and that you would want to go further and document that candidacy. Again, candidacy is based on the risk of entering foster care absent those preventive services. Basically saying if we don't do these things, we being what the family is responsible for and what we as the division or the county service provider is responsible for, then that child would be coming into care. And for a child to be considered a candidate, a child welfare worker has to have a direct conversation with the family about why the child is at serious risk of entering foster care without these services. This part gets into the issue of the case planning process. This can be a very uncomfortable yet critical conversation that has to be entered into honestly and not threateningly. This is always a challenge for us. We carry a great deal of power, both literal power that's given to us by the legislature and perceived power that families believe we have over them, whether we do or not. So we have to make sure we're having these conversations appropriately. Now, if the worker feels it would be untrue to tell a family that the plan is foster care absent preventative services, then this may be an indication that the child may not meet the candidacy definition. Now, that's different than the worker being uncomfortable with having that conversation. If the worker is uncomfortable having that conversation, that's understandable. It is a challenging conversation to have, but that's an issue for a supervisory conversation between the supervisor and the worker about how to help the worker have the tools necessary to have that conversation. But if the worker or the supervisor feel it's not true and accurate to have that conversation, then we would say that you may need to reconsider whether that child is truly a candidate or not. Now, just because a child may not be or fit the definition of a candidate doesn't mean that we don't provide or shouldn't be providing in-home services for them. Quite the contrary. Statute requires us to provide in-home services in certain situations. So counties can and should provide in-home services to children who are not candidates or not yet candidates. However, if you're providing those services, you may not code those services to 4E, which means you may not code 215Z. You must use an alternative program code. Now, inevitably, this is when somebody will come up with the question of, Evan, I see I must use an alternative program code. What program code must I use? And the answer to that question is whatever program code the child is eligible for that you still have money available in your county. Remember what I said earlier about capped funds? Well, the alternative fund program codes that are available are going to be seen as capped funds. And if you want to know what funds could possibly pair with 215 in that situation to determine whether or not the child is eligible, I would tell you we have some great resources for that. We have Appendix 3.4, which has revised instructions on coding options for 215 services for children who are not candidates or not yet candidates, because remember my example, child enters in-home services just January 3rd, but you don't complete the case planning process till February. You would have to code something other than Z for January. But then in February they would. So they're not yet a candidate, but they're going to become one. So you can utilize this appendix, and there's a link to this specific appendix here at the bottom. There is also a very cool daysheet training webinar that is available on NCSW Learn. It's available on demand. So you're able to watch that webinar at any time and be able to address those issues. You can get right to the section. The PowerPoint's pretty clear about what areas of practice we're talking about at any given time. So we would encourage you to both use those as a refresher as well as for new staff as well. So it will help answer a lot of those questions for you. So speaking of questions, I'm going to pause for a minute and allow you to catch up with my blistering pace as I've been talking on here, and make sure that you have a minute or two to type in any questions you may have about candidacy. And again, even if a question comes to you later, type it in as Rick has put up. We're capturing all the questions. And we'll try and answer them. If we don't get to them now, we will be happy to make sure they are answered in the FAQ document. So I'm just going to pause for a minute while you, anyone who needs to type in does. So a couple of questions that have come up that we do want to ask, and I appreciate y'all typing them in, that we can answer because they are kind of short. Unfortunately, Heather, you're absolutely right. Diligent efforts to develop a case plan don't count. It's a nice thought. There are areas where diligent efforts do count towards certain things. Here they do not. Another person asked if the social worker is unable to do a case plan update at 90 days because the parents can't be located, does that negatively affect 4E eligibility? It's a great question, Kim. Remember that the guideline from the federal government is every 6 months. So as long as you can get that update in within 6 months and reestablish that eligibility or redefine, you're okay. You may be addressing issues / violations of North Carolina policy because the update for the case plan itself isn't done. But from a 4E perspective, as long as you have at least one update every 6 months, the federal government would say that you're covered. So that's a great question as well. So thank you for that. Another good question that was asked that we can answer is, if you're only able to meet with one parent to get a case plan signed and have to meet with the other later, can you code 4E or must you have both? In general, the answer to that is it depends. And what we would say is that primarily if the person who's signing the case plan is the parent that is primarily at issue, the offending parent, for lack of a better description, then we would say yes, then that one parent's signature counts. Where it becomes a little more problematic, and I'll defer to Beth in a second to let her flesh out this answer a little bit from the 4E coordinator perspective, where it becomes more challenging is if you have two parents living separately, and let's say the parent A is the offending parent, the one who's caused all the issues that you're wanting to address and really puts the child at risk. Parent B lives outside the home but is involved, but really has been the non-offending parent, and parent B is the only one who signs the case plan. It becomes a little more challenging because really you haven't addressed the preventative services that you would be needing to apply to the child with parent A, who's the one who's going to have to participate in those services. So I would say you're on weaker ground in that example. But if the example would be two parents are living in the home, both of them are involved, and one parent just is away from home or can't come to that meeting, and that parent A signs, I would say in that scenario, yes, you do kind of meet the intent of the requirement. But I'm going to pause for a minute and let Beth jump in and see if she has anything different to say.
No, I would have to agree with you on that, Evan. When we were consulting just a while ago, that was my stance on it, that if you had two parents, like you said, for lack of a better word, the offending parent and the non-offending parent, you didn't want to have the signature of the non-offending parent and not having the signature of the offending parent, or not having their involvement with the plan, who you really need to have their involvement because they are pretty much the reason why you're involved with the child, with the family. So you need to have both signatures.
And I think what I would say also as a follow-up to Heather's question is a hearty, it depends. And what I mean by that is it really depends on the circumstances within the situation. And in that point, I would encourage you to reach out to either Beth as your 4E coordinator or your regional child welfare consultant about the specifics of the case to really determine what the situation is. Because yes, I could argue there are some times that the non-offending parent has taken steps that would meet the requirements, or there may be times that the non-offending parent doesn't meet the qualifiers as well. So you really need to look at the unique situation that way. And for parents who refuse to sign, that's also a bit of a unique situation. However, there's a difference between a parent refusing to sign and a parent refusing to participate. If the parent is willing to participate but are not willing to sign, and we all know there are times parents, either on the advice of their attorneys or just they're being difficult, for lack of a better word at times, whatever it might be, if they have participated but not signed, a lot of times we can work around it by getting a statement that says, I have participated in this plan, but am choosing not to sign. I acknowledge I was a part of this, but not signing the actual plan. Something like that would help us address that situation as well. But again, when you get into those situations, and hopefully they're fewer and far between, but if you do, then you can reach out to your to the 4E coordinator, Beth, to your regional child welfare consultant, and they can help you tease out the unique situations here. The reality is that with 4E, as many of you know, there is no often cut and dry answer that's going to work for the whole time. Again, I think taking advantage of your resources is going to be critical in these scenarios. But those are great questions. For the purpose of time, I am going to move us forward now, but as we've said many times, we're capturing every question. If we have time at the end, we may circle back on some of them, but if not, we definitively will make sure that we get all of them answered as part of the FAQ documents. So the next section we're going to move into is talking about the use of 4E funds to reimburse administrative costs for children in foster care. Now remember, we're talking about now administrative costs. Again, that is different than maintenance costs. Maintenance costs are the costs for room and board. Those are the costs you document on your 5094. Administrative costs are your day sheet costs. They're the costs related to the activities and services that your worker is providing. And we're also now talking about for children who are in foster care. Up to this point, we've been talking about candidacy administrative costs. Now we are talking about children who are in foster care. So we're talking about the 109 coding at this point. So that's just an important kind of umbrella to recognize that we're keeping and moving to at this point. So in general, some general thoughts and comments about 4E admin claiming in foster care. One of the first things that's important to know, and it seems like it should be fairly obvious, but you never know. Both Beth and I have seen plenty of reviews and audit findings where a child was not eligible. So the first thing we have to do is make sure that a child is 4E eligible as per the most recent 5120 or 5120A or NC FAST eligibility process or eligibility redetermination. If your child isn't found to be 4E eligible based on that document, then you shouldn't be claiming 4E regardless of anything else. Unfortunately, we have seen a number of situations where a 5120 or NC FAST is very clear that that child is not 4E eligible, and they've even checked the non-4E box on the 5120, and somehow either due to a clerical issue, somebody hitting the wrong box, hitting the wrong keystroke, they started claiming 4E. So it's critical that you keep track of the child's eligibility. Then they have to have been at least one day in the month in an approved licensed foster care facility that has an ID number issued by NCDSS. What that means is there are a lot of facilities and a lot of placements all across the state that may have different types of licensure from different North Carolina agencies. It doesn't mean they're bad agencies if they don't have a North Carolina division licensure number. It just means they're licensed for something different than what we approve licensure for. So if you have a facility that has a license number issued by Black Mountain, you're good to go. And some of you know these numbers as H numbers, Z numbers if we're talking about 18 to 21 program. There are different numbers that go along. I think there's A's and B's that go with it. But basically, if a facility has applied to Black Mountain to say, we are licensed to provide child care and we want to be licensed by you, then Black Mountain's going to approve that and issue an ID number. So if the child is placed in a facility that is considered licensed and has that number, you're good to go. And as I mentioned earlier, admin claiming is day sheets, not maintenance payments. Now, we want to talk about a couple of things here, and I'm going to end up repeating this multiple times because it is so important. Many of you remember that FPSA established a 2-week time limit on reimbursement for children placed in certain licensed group settings after October 1st, 2021. Primarily, we're talking about group homes. Such settings are still licensed by NCDSS, regardless of their reimbursability status as it relates to FPSA and 4E. Based on that license status still existing, administrative costs can continue to be claimed for 4E for children in such settings after the 2-week limit on maintenance payments has passed. I'm going to say that again to let it settle in. If you have a child who is being placed in a new placement in a group setting after October 1st of 2021, and the child is 4E eligible, you're required to stop getting 4E reimbursements. The federal government will not reimburse 4E payments after 2 weeks. However, you may continue, as long as that facility remains licensed and the child remains 4E eligible, to continue to claim Z on your day sheets for those children beyond that 2-week window. And in general, the rule to keep in mind is if a 4E eligible child is in a 4E approved placement, of licensed placement, as we discussed in the first bullet on this slide, for 1 day of the month, 4E admin can be claimed for the entire month. Now, like any good rule, there are going to be exceptions to that, and we'll talk about those in a few minutes. But I want to give you some examples of 4E admin foster claiming. In both of the following examples, 4E admin can be claimed for every day of the month. So example 1, the 4E eligible child is placed in a licensed placement on the first day of the month, so they're in the Smith licensed family foster home, and then moves to a non-reimbursable placement on the 5th day of the month. They go to Aunt Joan's house. Aunt Joan has been approved. She wanted to care for the children. You guys checked out her home and said, hey, this is a good place. We want to go ahead and place them there. So you do so. The child is still going to be 4E eligible for admin time for Z for the entire month. Starting the next month, they would not be, because it's not a licensed placement. But for all of the month of the move, they would be. And then the converse is essentially true. The 4E eligible child spends the first 25 days of the month in a non-reimbursable placement. They're with Aunt Joan for the first 25 days of the month. And then on the 26th, the placement disrupts, unfortunately, and the child is moved to the Smith family foster home, which is licensed. You may still claim all of the month as 4E admin, 109Z, even though they were only in a licensed placement from the 26th till the end of the month. Some further examples. A child is placed in a licensed placement or other 4E reimbursable placement, but no maintenance payment is received because SSI is being used for the board rate. This is fairly common. A lot of the children that we have come into care may have SSI. If you keep SSI in place, regardless of who the payee is, if it's you as the county, if it's the child's trust fund, if it's some other family member, if SSI dollars are still being sent out on behalf of that child, you may not use 4E as a reimbursement for any of the maintenance payment. However, if that child is in a licensed placement, you may claim 4E admin for that child. You may code Z even though you're not receiving 4E maintenance payments. And then the second bullet is just a restating of what I said earlier. The 4E eligible child is placed in the licensed group facility, but no 4E reimbursement is received due to the 14-day limit on reimbursement for certain facilities. So again, beyond the 14 days, and we're keep repeating this because it is critical to understand. This is new to us. We know that since October, but it is different, and we want to make sure that counties give themselves credit and get credit for the work they're doing and the maximum reimbursement when it applies. And in this case, that would be allowable. Final example that we want to make sure that folks understand is if a 4E eligible child is in foster care in a licensed placement in another state via the interstate compact, we want to make sure that you understand that if you have a child who is placed in another state in a licensed placement, hopefully, first of all, you are utilizing the interstate compact. If you are not utilizing the interstate compact and have placed a child in another state at that point, there may be other practice and policy and legal considerations you may need to take into conversation. I would highly encourage you to have those conversations with your RCWC and make sure you've not placed a child illegally. Other states tend to frown on that, as do we if we end up with a situation like that here in North Carolina. But if the child is 4E eligible, they're in foster care in a licensed placement in another state via interstate compact, you may claim 4E reimbursement for admin costs, day sheet time, for the work that your worker is doing. Now that work may be a little less if they're not here, because your worker may not be making all the visits they might normally, but anything they do in terms of case management could be coded to 109Z. So if it's foster care. So we want to make sure that you are aware of that exception. Now, as a general claiming rule, administrative expenses, day sheet time, cannot be claimed to 4E for any foster child who has not been determined to be 4E eligible or has not been in a placement licensed by NCDSS at least one day of the month. And that makes sense given the slides we've talked about already. If a child isn't 4E eligible, they would not be allowed to claim 4E, or if they're 4E eligible but hasn't been in a placement licensed by DSS at least one day of the month, then you wouldn't be able to claim admin. So you're probably saying to yourself, Evan, that is a great rule. We are glad you gave us something simple and we can just have this rule and move on. And I would say, not so fast. Just like any good rule, there have to be exceptions. The good news is these exceptions are rules that are going to help you maximize your reimbursement. And I know people like to maximize reimbursement. So let's talk about those. So one of the first exceptions we have is when a 4E eligible foster child is on runaway status. And what that means is, and unfortunately we know, especially with some of our older teens, children, we may place them in a licensed placement, family foster home or other type placement, and they're on the run. As long as we are doing, and this gets into some of the question about diligent efforts before, where you actually get credit for some of your efforts, as long as we're making the efforts both to find the child, and as my attorney in Forsyth County used to say, you actually have to look for them like you actually want to find them. But as long as you are actively doing what you need to in regards to case management, that would include trying to find the child, holding CFTs and PPATs as required, going to court as regularly required, doing all the paperwork and things that the case would require as if the child were present. As long as you're doing all those activities, then while the child is on runaway status, you may claim 4E admin time for the work that your worker is doing. Now, again, that may be a lot less time, or it may be a lot more time in the short term, depending on what the look entails. But a child on runaway status, while you're not claiming 4E maintenance necessarily, you could claim 4E admin time for that child. The second bullet that comes up, and a lot of you are familiar with this if you've been to 4E training before, is that if a 4E eligible child is in an unlicensed relative home, and I'm going to pause here to say it must be a relative's home. They must be a blood relative. It can't be fictive kin. It can't be your friend John who's as close to you as family and maybe closer than your family. That's wonderful and it's a great resource for that child, but unfortunately fictive kin don't qualify, nor do just family, friends, or well-intentioned community members. It has to be a relative. But if the 4E eligible child is placed in an unlicensed relative's home where an application for licensure or approval of the home as a family foster home is pending, what that means is the relative must be actively involved in the process. Now, that doesn't mean that the license has to be submitted to Black Mountain and waiting for the license to be returned. They can be actively involved in the certification process, MAP, whatever program you're using. They could even be on the waiting list for the next class. If, let's say, you place the child today with a relative, with Aunt Joan, and Aunt Joan says, I want to be licensed, I want to go through it, and is ready to sign up, but the next class isn't until March 1st, you could theoretically start now because they've signed up. It's not the relative's fault that your next class of opening is until March. However, it is important to remember that exception can only exist for a maximum of 12 months. So if the licensure process takes longer, we know for some folks with COVID impacting our process, it can take a little longer than it might normally. It can't take longer than 12 months. It also can't be utilized while the family is just making considerations of licensure. They have to be actively involved either in the licensure process or signed up and awaiting the licensure process to begin. Another exception that we don't always utilize or are aware of is for the entire month prior to the month in which a child moves from a facility ineligible for payments to a licensed placement. So I'm going to give that to you as a more concrete example. If the child has spent December of 2021 in a PRTF or another facility that is not considered a 4E eligible facility, and moves in January, even if, let's say today, January 27th, to steps down to a licensed family foster home. Okay, the entire month of December can be claimed as 4E. Now, the day sheet period will have closed because many of you are aware that for the service month, like for the month of January, you have up until February 5th to make adjustments to your day sheets, and then the system closes on February 5th and locks. There still can be adjustments made with your fiscal office. It's a little more complicated, and they have to work with your LBL on that, but it is possible. So for the entire month prior, my example of December, you could go ahead and claim that to 4E admin, not maintenance, but 4E admin. And then all of January would be able to be claimed as 4E admin because remember, they move on the 27th, so they're in a license placement one day of the month, which means you get all of January as well. So I'm going to pause for a second there and let that settle in before I move to our last bullet here, because this last bullet is somewhat of a significant change to guidance that's been in place prior. And this is related to trial home visits. And generally, children on trial home visits are not eligible for 4E administrative claiming. The exception to this is if the 4E eligible child spent every day of a federal fiscal quarter in a court-ordered trial home placement. Now, there are several things to unpack with that. The first of which is, what is a federal fiscal quarter? The federal government works on different concepts of a year than we do. It's not a calendar year, and it's not our state fiscal year. The calendar year starts in January. The state fiscal year starts July 1. The federal fiscal year starts October 1st, and the federal quarters are October 1 through December 31, January 1 through March 31, April 1 through June 30th, and July 1 through September 30th. So in order for a child to be eligible for 4E claiming admin on a trial home visit, they must spend every day of the federal fiscal quarter in a court-ordered trial home placement. What that means is if they are not in that placement on the first day of a federal fiscal quarter, whether that's October 1st, January 1st, April 1st, or July 1st, if they're not there on that date and then don't stay through the full quarter, they will not be eligible for admin time reimbursement based on this requirement. And you would have to code non-4E. If they are in a trial home placement on January 1st, but they go home on January 31st, you terminate care, they were not in for the full fiscal quarter, despite the fact that custody was dissolved, you would not be able to claim trial home placement that time to admin claiming. So essentially, your trial home placement, if it qualifies, is only going to be retroactively allowable. You're going to have to look back, and it's going to require you to then make those adjustments with your fiscal office. This is part of the reason, among many, why it's always good to be on good terms with your fiscal office. There should be good conversations happening regularly between child welfare and the fiscal management office for any number of reasons. So I'm going to pause there for a brief second and let that sink in. Let's see if any questions percolate up. And then we're going to go into our final section where we're going to talk a little bit about the actual use of the DSS 5094, specifically Field 55. All right, well, I'm not seeing any jump in, which either means I am being incredibly informative and answering everything that you ever could have had about this, or you have fallen asleep during the webinar. Now, the important thing to keep in mind is if you are in a room with someone else, please make sure if you fall asleep that you don't snore loud enough to wake them up. It's rude. Everybody deserves their own nap time, and we want to make sure that you get that they get that opportunity. So if you're going to snore, snore quietly. All right, so moving on into the actual 5094, and forgive me, I typed a little too fast. So the 5094 is the form by which we enter data into the Child Placement and Payment System, CPPS. And CPPS is the system by which we track funding source eligibility. We track any number of things. That form, those of you who are familiar with it, know all the different fields on it are utilized to track a number of things for state data as well as federal data, reimbursement, a little bit of everything. So the 5094, as you know, is, for those of you that are paper counties, is that 3-ply form, white, pink, and yellow, I believe, are still the colors. If you are not a paper county, if you're an NC Fast county, then you're going to be able to get this data entered through different fields that you enter in NC Fast. However, as it says here on the slide, NC Fast still takes that data and enters it into the CPPS system. So NC Fast is not doing a separate issue and handling this separately. It's taking that information that you're entering and uploading it to CPPS. So as a whole, CPPS is the system that we use. It is important to remember, however, that when we talk about updating the 5094, what the closure date is. The closure date for a 5094 is the 19th of the month following the service month. So for example, we are in the service month of January right now. That means that any changes that you make for the child in a 5094, any changes you make up until February 19th are going to affect the service month payment month of January. This is where we see people get into a lot of trouble in audits and reviews around initial entry. And many of you have been in our 4E trainings and before know this example, but the example would be the child comes into care today on January 27th, but you don't get the legal language you need until the 7-day hearing, let's say, on February 3rd. So your worker is very smart and is very skilled, and they go ahead and come in that they come into the office right after taking custody today, and they say they're not 4E yet. I don't have the legal requirements. I fill out my 5094 for my supervisor. I mark state. Then I go ahead and on February 3rd, I get my court language. I have an order from my judge because my judge is all that in a bag of chips and gives me my order. I come back to the agency. I update my 5094 on February 4th because my supervisor wants me to be timely, and I change it to 4E. I've done everything right. I've got my paperwork done timely. Life is good. And unfortunately, the answer is what you've done, albeit well-intentioned, you've created an error because the update you will have done on February 4th affects January, not February. So you will have made January not 4E, which would be ineligible. And so I just bring that up as we start talking about the 5094, so you remember that closure date of the 19th of the following month, that you would go ahead and make sure the update is there. And Heather asks an excellent question. Why is the language not in the non-secure order? Well, this is a kind of a hypothetical example. Unfortunately, we've seen plenty of times where the J150 may not have been filled out correctly, so you don't get that language. It wasn't signed right. The judge checked a box differently. In a perfect world, yes, you would get the language, and we can, if you're using the most updated J150, you get all that language in the initial order. However, there are still plenty of counties that are either unfortunately using old J150s or judges don't fill it out correctly. So great question and good catch that it should be, but should is the most dangerous word in the English language, so we try not to use it if we don't have to. So understanding that about the CPPS system, let's talk about the field we're going to focus on today, which is field 55. Okay, this field tracks the funding source being claimed for the child's cost of care. Now, everything I'm about to go over with you, you'll be able to find in the link to the CPPS manual that is at the bottom of this slide here. So I don't want you all to feel like you have to write down every piece of information I'm about to give you, because we're going to go over a lot in a short period of time. But everything that I'm about to discuss is in that manual for you. Those instructions are pretty solid as far as this goes. So what we're talking about here in field 55 is the funding source. It's saying what is the child eligible for. This helps us track not only what funds and reimbursement the money that's coming back to you as a county should come from, what pot, but it also helps us track in our data what percentage of our children are 4E, which percentage are state, and those formulas and that data is critical to both the state and the federal government for a number of reasons. So when you should use the 4E box, which is the top box, we're going to talk first about under 18. Okay, keep that in mind. This is for children up to the age of 18. We're going to talk about extended foster care in a second. But for children who are under the age of 18, you would enter an X in the 4E box if you're making an assistance payment, a maintenance payment, for a 4E eligible child who's in an approved placement with a license number issued by NCDSS. That should sound familiar from the slides that we had earlier. Unless, so before we get to the unless, if you're paying maintenance payment, it's a license placement with a number issued by NCDSS and they're 4E eligible, you're going to check that box. The exception is if the child has SSI funds that are being used for all or part of the maintenance payment. And if the child is receiving SSI of any kind, then you can't use 4E. So if they're receiving it, you should be not checking the 4E box. At that point, the 4E box should be left blank. Okay? Now, you're going to enter X in the 4E box if an assistance payment is being made for a 4E eligible child placed in an NCDSS licensed group home, regardless of when the child was placed in the facility. This is important to remember as it relates to this new rule. If the child is 4E eligible and the facility maintains NCDSS licensure, you don't need to change that box based on the 2-week rule. The system will calculate that based on when the child went in, when they've been there, etc., etc. The system calculates the 2-week limit for new placements made after September 30th and will make the appropriate adjustments. So you don't need to change it. Okay, so that's when you're going to use the X in the 4E box. Child is 4E eligible, you're making a maintenance payment to a NCDSS approved placement. and or they're 4E eligible, but they're receiving SSI, then you would leave that blank. But if they're 4E eligible and a 4E placement, check that box and you're good to go. You would put an X in the TEA box if an assistance payment's being made for a TEA eligible child, and TEA is an eligibility you would determine on the 5120 or in the NC-FAST eligibility process, who is not eligible for 4E and doesn't have SSI. If TEA is determined to be the funding source, then a date has to be entered in field 54, which I haven't pictured here. If TEA is coded and the begin date is not the first day of the month, the system will reimburse from state SFHF funds only for that month that you didn't put the first of the month, and then from TEA for subsequent months. Now, some of you may be concerned or panicking going, what's TEA? I've never heard of it, or do we have that? Do we not? Not every county gets TEA funds, but not every county uses TEA for the actual maintenance payments of a child in foster care. There are a number of different ways that TEA funds can be utilized throughout the life of child welfare. Most counties spend down and overspend their TEA pots. So if you've never heard of TEA in your county, it's likely you're not using it. Your county is choosing not to use TEA for foster care, in which case you can ignore this. If you are a county that uses TEA, it's critical to make sure that you have TEA funds available. Again, we're going back to the ongoing conversations with your fiscal staff so you can make sure you're making the right determinations as far as that goes. And then finally is the state box. You would put an X in the state box if an assistance payment is made for a child who is not eligible for 4E or TEA. You also would enter this X in the state box for a 4E eligible child whose SSI funds are being used for the foster care assistance payment. So again, they're 4E eligible, they get SSI, so then you would check X in the state box for anything above what the SSI doesn't pay for. Okay, and so remember, for under 18, it's X marks the spot. You put an X in these boxes. So now you're probably saying to yourself, that's great, Evan, but what if we have children in or young adults in the 18 to 21 program, the extended foster care program? I would tell you that is also a great question, and allow me to answer it for you. For young adults, you would enter E as in Evan or extended. I'm very narcissistic, so I think it should be for Evan, but it's probably for extended. But you would enter E in the 4E box if an assistance payment is being made for a young adult who is 4E eligible. You enter E in the state box if an assistance payment is being made for a young adult who is not 4E eligible. Again, that eligibility is going to be determined by the 5120E. Again, that E could be for extended, could be for Evan, but it's the 5120E or the NC-FAST eligibility process. And again, all this information is in the instructions that you can link to via the link that's on this page. Now we get to the last part of Field 55, the 4E admin eligible box. Now, I want to point out, this is actually part of Field 55, despite the fact that it is kind of a little bit under the Field 56 there. It's actually part of Field 55, and you'll find the instructions for it in the manual under Instructions for Field 55. So the 4E admin eligible indicator box, try saying that 4 times fast, is utilized to identify children who would be 4E eligible or young adults who are eligible for administrative payments during the month, even though 4E wasn't used to reimburse the county for a maintenance payment. Again, this is a data indicator. It helps us determine how many children in the state are truly 4E eligible at any given time. That number is critical to us because it relates to the penetration rate. The penetration rate is essentially the number of children The numerator is the number of children who are 4E eligible. The denominator is the total number of children in foster care. And that percentage relates to the payment percentage we get from the federal government. So we want to make sure our penetration rate is as accurate as possible. And so utilization of this box is critical for that need. But you would go ahead and put an X in this box in certain situations when the following scenarios would be true. So example number 1 would be a 4E eligible child's SSI is being used for foster care assistance payments. So going back to the previous example, previous slide, when I said you have a 4E eligible child where they have SSI, so they're not getting 4E as a funding source, but you've either used SSI for all of their payments or SSI and state for some reimbursement, you would make sure there is an X in the 4E admin eligible box. A 4E eligible child is on runaway status for a placement from a reimbursable placement. If they are in runaway status, you need to make sure this box is checked, because remember I said earlier you can utilize 4E admin time for that. However, but you need to make sure that you would go ahead and check that box so we can calculate that child as part of the penetration rate. If you have a 4E eligible child who is placed in an unlicensed relative home at least one day of the month and they have an application for licensure or approval pending, you need to check this box. And a 4E eligible child who is in a court-ordered trial home placement every day of a federal fiscal quarter. Again, you'll notice that these examples all line up with the ones where we told you exceptions where you can claim 4E for admin time. Those exceptions mean that we want to go ahead and make sure that you are getting the calculations entered into the data stream. So if you're able to claim that 4E, it's not enough if you claim it on the day sheet. That won't tell the system that this child is 4E eligible. So you need to make sure that a X is placed in that box if any of the following that we gave you are true. And again, you can link to those instructions via the manual right there. So I'm going to pause for a minute and allow you all to type in some questions. I saw a bunch of people were doing some questions, so I want to make sure we get those. I'm going to scan the box real quick. We're right near the end of our time, and I know that Rick has some administrative stuff we need to finish at the end. So let me take a quick look here.
While Evan and Beth are researching that, let me just put up their contact information too so you can capture that. So we do certainly have some questions we have captured. We've captured all of your questions. So they're taking a look at those right now to see, because we obviously only have a few minutes left here today. If there's anything they might be able to quickly answer, but fear not, if we do not, we can add them to the follow-up document. Here's their contact information if you wanted to reach out to either one of them directly after the presentation. I will post the file share box one more time too. Let me get that for you in case you wanted the handouts. Here they are. Just click on it if you want to download the webinar handouts for today. And Evan and Beth, is there anything that you wanted to try and quickly answer before I give you all some final steps of how you close this out today?
I'm not seeing anything specific. I do want to respond to the one example, and we will make sure all these questions get answered. So please don't hear me say that the questions aren't important enough to answer. It's just they may not be short enough to answer, but we'll make sure they go in the FAQ document. But one that I did want to answer, Pam had asked, so a child goes home on February 15th, had been living in a licensed foster home. Custody was returned on 5/1. We can count 40 until 3/31, correct? And the answer to that would be no. If they were in a licensed foster home on February 15th and they go to a trial home placement on February 15th, you could claim all of February, but you can't claim the time for March because they were not in the trial home placement for the entire month or entire quarter. They would have to have been in the trial home placement for the entire quarter. That's what makes these claiming requirements much more challenging. It's not just that they have to have been in a licensed foster placement and then a trial home placement for the entire quarter. It's that to claim it for a trial home placement, they have to be in that placement for the entire federal quarter. So I did want to take that one because that was a specific example, although it is a good one and we will use it as part of our FAQ as well. We will definitely address some of these as well. And so, Taisha, you did ask, and this is related to those exceptions, if a child's 4E eligible and placed with a grandparent, do I check the 4E admin box? The answer would be it depends if the grandparent is actually pursuing licensure. If they are not pursuing licensure, then they wouldn't be 4E admin eligible. It's only, you would only check that box as it relates to the licensure status, because otherwise a relative is not considered eligible at this point. But it's a great question and good clarification, and we will make sure that gets into the FAQ as well. In regards to the other questions, some of you have asked about the yes or no versus an X. The X are the instructions that we have currently for the 5094. However, this was also asked in one of the other webinars. We're going to clarify that with the CPPS people and make sure that the correct information is reflected in the FAQ document as well as the policy manual if any updates need to be made. So with that, I think I'm going to go ahead and stop because I know Rick has a few things he needs to go over before we finish. But we'll also stay in the room to make sure you have other questions and we catch those at the end. But I'm going to pass it back off to Rick. Thank you.